Business Immigration podcast on the Common Skilled Worker Licence Pitfalls. My name is Briar Coco. I'm a senior paralegal here in the Doyle Clayton Business Immigration team. I'm joined today by Al Harvey, Associate, who specialises in the skilled worker sponsorship route.
Hi Brian, nice to be here.
Thanks for joining me. Today we're going to be looking at common mistakes made by businesses administering their own skilled worker sponsor licenses. It can be very overwhelming navigating the rules and the Home Office guidance. Many clients do come to us after they have attempted to handle matters themselves. Today in this podcast, we will summarise the issues we tend to come across in practice. The first issue we often see is assigning a new entrant COS incorrectly. Al, can you talk to me about this?
Yeah, so the COS, or the Certificate of Sponsorship, is assigned by a sponsor to a skilled worker in this case, and is needed by the individual in their visa application. When assigning a Certificate of Sponsorship, you have to pick a subcategory, and one of those is for new entrants to the profession. Many sponsors tend to think that new entrant means the individual's not held a skilled worker visa before, but it's actually a defined term found in the immigration rules, and it includes applicants under the age of 26, recent students, and graduate visa holders. The benefit of the new entrant route is that the individual benefits from a lower salary threshold, and it is considerably lower, 70% of the going rate, compared to the full salary requirements. Incorrectly relying on the new entrant provisions could actually result in a visa refusal. So it is important that sponsors are aware of the distinction when assigning a certificate of sponsorship, and are sure that the applicant in question does in fact meet the new entrant requirements. It's also worth bearing in mind that new entrants are limited to 4 years under the skilled worker route as a new entrant if they've already spent time as a graduate. So it's very important to ensure that when assigning a certificate of sponsorship, one, you are sure that the new entrant is in fact a new entrant in accordance with the immigration rules, and two, the length of time you're looking to sponsor the individual for falls within the permitted cap.
It's an easy mistake to make, that one. Thank you, Al. The next common issue that we see is selecting the skilled worker graduate in Tier 4 student route certificate of sponsorship option for graduate visa holders. Can you expand on that, Al?
Yeah, so this is one we see quite often actually. So the certificate of sponsorship, the subcategory in question is entitled Graduates in Tier 4/Student Route. And I think a lot of people read the word graduate and assume it applies to those who currently hold a graduate visa, so a post-study visa. But it's actually intended for those currently holding a student or a Tier 4 student visa. And it's an important distinction because relying on this type of subcategory certificate of sponsorship does not incur the immigration skills charge, which for medium and large sponsors is £1,000 per year.
Certainly makes a difference, doesn't it?
It certainly does. And it's one of the benefits of switching immediately from a student visa into the skilled worker route, is that you are exempt from the immigration skills charge. But often we do see sponsors incorrectly assigning certificates of sponsorship to graduates under this category, and therefore not incurring the immigration skills charge. There are issues with this. Best case scenario, the Home Office get in touch with you, send you a payment link so that you can pay the missing immigration skills charge. Worst case scenario, they refuse the application because it's incorrect. The certificate of sponsorship which has been assigned is incorrect. So for your graduate visa holders who you're looking to sponsor as skilled workers, you should be assigning the switching immigration category certificate of sponsorship, not the confusingly named graduate in Tier 4/student route certificate of sponsorship.
Thanks, Al. The next common pitfall we'd like to discuss is running out of undefined cause and then having an urgent need for one. We see this quite a lot in our practice. Can you talk to me about that?
Yeah, so I mean, historically, sponsors would every year need to, well, the majority of sponsors anyway, would need to manually top up their undefined certificate of sponsorship numbers, depending on their anticipated needs for the forthcoming allocation year. These figures now, or these numbers, sorry, are now automatically topped up based on historic use.
It's all changed, hasn't it?
It has, yeah. So recently, actually, the Home Office have changed, they've automated it so that essentially you are given an allocation based on how many certificates of sponsorship you used in the previous year, which could mean insufficient need for your recruitment plans. In that case, the onus is on you as a sponsor to manually top up or request additional undefined certificates of sponsorship. Often, the realization of this comes about when there is an urgent recruitment need, or perhaps you've got an individual, a current sponsored migrant whose visa is coming up for renewal and you need an undefined certificate of sponsorship to extend their stay. The problem is that standard processing for undefined certificate of sponsorship top-ups is up to 18 weeks.
A long time.
It is a long time. And for most people, it's too long, particularly, if you've got visas expiring or, you've got potential new hires in the pipeline waiting to join, 18 weeks can be a barrier for many. There is the option to prioritize the request, but these requests are very few in number. I think it's 60 slots a day.
That's right, they're very hard to come by.
They are. You need to apply, you need to email at 9 a.m. on the dot, or if not slightly earlier, 8:59 to request a priority slot. And having spoken with other practitioners, it can take days or weeks to secure a priority slot.
That's right.
It seems a slightly archaic system. There is discussion about it potentially being automated. Some practitioners have had success in marking their emails as urgent, but if you are unable to secure that priority slot, your hands are somewhat tied. And in the circumstances, it can leave people really unsure what to do, particularly if they've got pressing deadlines or visa expiry dates coming up. It's just worth bearing in mind that as a sponsor, I'd be recommending sponsors are regularly logging into the sponsor management system to check how many undefined certificates of sponsorship they do have, and perhaps, making a request for additional numbers in anticipation of any needs. It's always useful to plan in advance.
Definitely. That's right. Thank you for that, Al. That's very useful to know. Another common pitfall is not keeping key personnel up to date on the sponsor license and having no access to the license when it is required. We see this quite a lot as well, don't we?
Again, yeah, it's something we see quite often. There are a number of positions on the sponsor license which are held by people in the organisation. There's the authorising officer, who is ultimately responsible for everything on the license and all the other people who have access to the license. And there's a key contact who, as the name suggests, is the person with whom the Home Office tend to liaise. And then there are level 1 users who do a lot of the administration of the license, and level 2 users who, similarly to level 1, do administration, but with less less permissions essentially over the license. And yeah, we tend to see sometimes clients come to us and say, well, our authorizing officer's left, or the only level 1 user we had has left. What do? We don't have access to the license. We don't have somebody in place to sign authorities or submission sheets. In the circumstances, there are workarounds. You can contact the Home Office to get access to a license. The issue with that it gives the impression that as a sponsor there's been a dereliction of duties. You've neglected those obligations you have as a sponsor. And whilst I don't have anything concrete to support this point, for me, it would be a flag on the system from the Home Office if they think you as a sponsor are not complying with those obligations.
Could definitely trigger a Home Office compliance visit.
I think so, yeah. Or at worst, it puts you on the radar. So I would be suggesting, again, it's just a case of not forgetting that the license is there, even if you're not using it all the time, just to make sure that the people who need access to license are still there, that there are sufficient people with access, and that if there are changes in senior staff, perhaps in the HR department where most of key personnel tend to sit, that before they leave, there are steps taken to ensure that if they do hold these positions in the license, that they are replaced with appropriate people.
Ideally, before they leave the business.
Definitely, because it just helps things run a bit smoother. And I think also it helps avoid any temptation to share or use somebody else's level 1 user details, which categorically should not be done, as it is grounds for a license to be revoked.
Very serious consequences for sharing level 1 user details, isn't there? Thank you, Al. Next on the list is sponsoring migrants to work for an entity which is not on the license. This can get messy sometimes, can't it, Al?
Yeah, I think the issue is that we often see organizations change over times and grow and develop with subsidiaries and sister companies and parent companies being formed and created as an organization. Changes form after having already obtained its sponsor license. It's, in terms of context, you can have various entities all under one sponsor license, providing they are linked by common ownership or control. That tends to be the most common or the typical connection we see connecting entities under a license. So whether it's advisable having various entities under one license will ultimately depend on that business's structure and their processes. It's important that there is sufficient visibility between the entities and that key personnel on the license has oversight of what's being done under all the different entities, or as the Home Office call them, branches on the license, to ensure that it can meet its reporting and monitoring obligations. So going back to your question, sponsoring migrants to work for an entity which is not on the license, that is something we tend to see in larger corporate structures. We'll often get clients say, well, we want to sponsor them to work for company A. Company B have the sponsor license. We do that. Well, in theory, yes, in this example, company A and company B share a parent company. They're both wholly owned by the parent company. That's fine. But the issue we tend to see is that the client doesn't know if company A is a branch on company B's license. And we would often be recommending they go back to the original license application to see if it's been disclosed as such. Unfortunately, many clients don't have that paperwork still, despite it being an obligation of them to have.
That's often the case, isn't it?
Yeah. So we then are in a situation where we either have to approach the Home Office to get them to confirm, or we make a request to add it as a branch to the license in hope that it hasn't been done already, which again would suggest that if it has been done, we are doing it again, then the license holder is perhaps not as on the ball as they should be. So that's what you do if you are looking to employ somebody to work under a branch on a license. It is important that before you look to sponsor somebody, that you are ensuring that it is a branch on a license or has its own sponsor license. Sorry, the entity has its own sponsor license. And again, linked to this, in a very similar situation we see is that we have migrants often being employed to regularly work from a new office site, which perhaps hasn't been reported against the license. The expectation is that if you are looking for somebody to work from a site, that site has been accepted onto the license first by the Home Office. So again, it's worth bearing in mind if, as a larger organization, you do have various office addresses and locations, that these are all recorded against the sponsor license. And it's something we can certainly assist with, but with larger organizations and corporate structures, it can get quite complicated. So
Quite complex, isn't it?
It is, and it just shows how important it is to retain records.
Keep them up to date.
Yeah, and especially if you have sort of high turnover of staff or perhaps change advisors, being able to show an audit trail of what has been reported and when will serve you very well going forwards.
Thank you, Al. Another common pitfall linked to that area is failing to report big corporate changes in time. Can you elaborate on this, Al?
Yeah, so I think, again, what we often see is that immigration matters and sponsor license matters tend to be the last thing that are really thought about when you have changes in corporate structure, or perhaps if an organization changes name or moves address or is part of a merger or acquisition, perhaps buys another company. It's so important that there are people in the organization who are aware that corporate changes of this type can and do have an impact on a sponsor license. And I think that, the biggest example to give, or situation to be aware of, is a direct change of ownership. For example, if, again, taking Company A in the example before, if Company A were bought by Company C outright, then Company A's sponsor license, if they had one, is technically being revoked. So there's a lot to consider there. If they do have sponsored migrants and they have a sponsor license, you need to take that all on board. The expectation is if in that situation Company C don't have their own sponsor license and Company A still wants the ability to sponsor, then Company A needs to be looking at getting a new license. So whilst I wouldn't expect people within an organization to be fully aware of what needs doing and when, I think having an appreciation for the potential impacts of certain changes and certain corporate changes, an appreciation of what those could have or the impact they could have on the sponsor license will just will just ensure that a company is in good stead to deal with it proactively rather than reactively. And unfortunately, we do tend to see a lot of clients having to deal with these matters reactively, which just puts everything on the back foot and just makes it a little bit more stressful and time intensive than otherwise would need be if perhaps immigration wasn't the last thing people were thinking about.
Well, thank you, Al. We have covered quite a few points today. Am I right in saying that the key points of the podcast are as follows? Ensuring that you are assigning a cause correctly.
I think, it's always important to ensure that you're selecting and assigning the correct certificate of sponsorship based on the specific applicant's circumstances.
Thank you. Keeping an eye on your undefined cause levels.
Definitely, yeah. Always logging in, checking your needs and seeing what might change, and trying to anticipate the needs going forward of the company.
Thank you. Ensuring key personnel on the license are kept up to date and still with the business so that they have access to the license.
Yeah, very important one. You don't want to lose access. You don't want to find a situation where you key personnel have gone and you're having to take steps to get people into place and back into the roles which are fundamental to ensuring you're compliant as a sponsor and can continue to administer the license as needs be.
Thank you, Al. And lastly, ensuring that your license continues to reflect the structure of the company.
Yeah, like I said, I think it's just trying to ensure that immigration is part of the corporate structure conversation, isn't a final thought, and just enables the company to act prospectively and as opposed to reactively, and ensure that it's well placed to undertake any reporting or any reporting obligations which might come as a result of corporate structure changes, and in the case of a merger or an acquisition, potentially requiring a company to apply for a new sponsor license. But I think if you're ever in doubt, just take advice on the matter.
Well, thank you, Al. And thank you for listening to the podcast. Please do get in contact with the Doyle Clayton immigration team if you'd like any assistance with your immigration needs.